And this is the idea. What happened in Nebby is really quite disturbing. It's the depths of the new depression, of the Depression era, and the federal government comes out with this regulation indicating that you can't sell a quart of milk for less than 9 cents a quart. It's a price floor instead of a price ceiling of all things. And Mr. Nebbia was convicted of selling 2 quarts of milk and a loaf of bread at 18 cents, which means he threw the loaf of bread in. The equivalent of a sale, you know, is crime to have a sale at your grocery store under some of the New Deal era regulation. And basically the close of the public interest test and the notion of freedom to contract went out the window and was replaced by this rational basis review that we have today. The idea that government could do anything in regulating business so long as it was rationally related to a legitimate government interest. Of course, we don't really know what a legitimate government interest is. That's left open-ended, and we continue to have that debate today. And the court also said the state is free under the federal constitution to adopt whatever economic policy may reasonably be deemed to promote the public welfare. So this is the rational basis test, which allows state legislators and federal legislators to do almost anything to your economic rights or your property rights, absent the state constitution. Similarly, 1938, Caroline Products, you again will study this, already have. The famous footnote 4 that bifurcates rights essentially creates 2 classes of constitutional rights, quite artificially. On the one hand, it creates a special strict scrutiny standard for freedom of speech, freedom of religion, certain civil rights, voting rights. And on the other hand, it relegates economic rights and property rights to second-class citizens, essentially. And again, rational basis review applies to those. So the legacy created by that deference really helped to make the Kelo versus New London case possible. But something interesting happened soon thereafter that you won't learn about, or didn't learn about, and that is the state of Ohio's reaction to the New Deal court in the New Deal era, which was similar to the reaction of many states. Ohio recognized in the 1940s, as this New Deal era jurisprudence progressed, that it needed to use its own constitution to protect individual rights, especially the right to be left alone and harmless in your property and business endeavors. And there was a 1941 decision by the Ohio Supreme Court that really speaks to this issue that you'll never hear about, but it's still cited to this day. It's good precedent. And this is basically New federalism encapsulated. The guarantees of sections 1, 2, and 19 of the Bill of Rights in the Constitution of Ohio are similar to those contained in the 14th Amendment, but if in the midst of our current trends towards regimentation of person and property, this long history of parallelism seems threatened by a narrowing federal interpretation of federal guarantees, it is well to remember that Ohio is a sovereign state, and the fundamental guarantees of the Ohio Bill of Rights have undiminished vitality. In other words, Ohio courts are free to use the Ohio Constitution and to step in and to fill that gap in the protection of liberty that had taken place after the New Deal era. And this ends up sounding a lot like the Lochner era that is supposedly repudiated at the federal level. And over the next 10 to 20 years, we have case after case of the Ohio Supreme Court invalidating regulations that would clearly stand up against the federal Constitution. Wage and hour regulations, hours that a barber shop can be open, hours that a grocery store can be open. All of these things are struck down. Equipment labeling requirements, they're all struck down as arbitrary and unreasonable. And again, the court stated, Ohio courts should be extremely zealous in preventing the constitutional rights of citizens by being frittered away by regulations passed by virtue of the police power. And the relation to the public interest and common good must be substantial, and the regulation must be necessary in order for the regulation to prevail over individual rights. And these precedents led us to the Norwood decision that I referenced earlier, where the Ohio Supreme Court indicated that Ohio has always considered the right of property to be a fundamental right. There can be no doubt that the bundle of venerable rights associated with property, which includes the right to use, acquire, and enjoy property, not mere ownership, are among the most revered in our state and are most fundamental. Now compare this with Caroline Products that I just mentioned, where it indicated fundamental rights are only voting rights, certain religious rights, civil rights, First Amendment, and then the rest of this stuff is not fundamental. So these rational basis. Here we have the Ohio court kind of asserting that property rights are a fundamental right, indicating that strict scrutiny should be used when we are scrutinizing the validity of those regulations. But the Ohio Constitution is not a purely libertarian utopia. You have a state power, kind of analogous to what we have at the federal level. And you have learned, or will learn, a lot of the Commerce Clause, which is the most powerful and broad federal power. And in some ways, the state police power, it's helpful to think of it as kind of the analogy, as analog to the Commerce Clause at the federal level, in that people are always claiming they can do anything under it. They're waving the banner of public health and public safety and saying that the police power allows me to do this. And the battle at the state level over the police power is exactly where the battle over the federal Commerce Clause is today. In other words, we're fighting the individual mandate, claiming that there must be some sort of a limit on the Commerce Clause. You know, it must be economic activity, or it must at least be activity before Congress can use its Commerce Clause power. Well, we have the same thing going on at the state level with the police power. The police power was originally defined by Locke to be the coercive powers of government, the power of government to use coercion against you to protect your rights from others. And that was its original conception that lived a long time. But again, around the progressive era, the police power started to be viewed expansively. I don't know that you study the police power very much in constitutional law here in law school, but it is the defining issue in most states. And the police power is generally characterized as the power to regulate for the public health, safety, morals, and welfare. And this becomes very complicated to understand because what you have through regulatory takings jurisprudence is this concept that if I take your property, I clearly have to pay you for it. But if I let you keep the title and I merely deprive you of most valuable uses of your property, I no longer have to pay you for it. And it's just a exercise of the state police power. So in other words, when the state's using its police power, the argument is that it owes you no compensation whatsoever for the regulation of your property. However, when the regulation goes too far, it's no longer an exercise of the police power, it's then a regulatory taking for which compensation is owed. And there's this whole gray area, and really Ohio judges have sort of forgotten the fact that there is a limit on the state police power. And what the smoking ban case is really all about is enforcing that limit. And what is that limit? Well, the limit is based upon externalities. It's the idea that government has the power to regulate you to stop you from harming me if that harm is imminent. For example, I could bring a nuisance action against you or a tort action against you of another kind if your factory is polluting my property, if there's soot all over my property because you've got an industrial factory running full bore right next door. And similarly, well, the idea is that that's an externality. The idea is that you are imposing a cost on me, and I can bring that common law action against you. What that means is the state then has the ability, through the police power, to also enjoin the pollution because it is a nuisance. And that's essentially our argument in the smoking ban case, and really in the broader scope, the police power in general. This is consistent with Richard Epstein's view of the police power as essentially a libertarian one that allows government to protect your rights from being violated. And this is very much based in kind of the Lockean roots that I referenced. And the smoking ban very much fails this test. So let's talk about nuisance theory. How many of you have studied nuisance law? A few of you? Well, the idea is the limits of the police power, the limits of a state's ability to regulate your property, regulate your business, is essentially based upon nuisance theory. And if you've read Lucas v. South Carolina Coastal Council, you've seen the statement that a state may do certain things based upon background principles of nuisance law. And indeed, the concept of the police power it exists the Ohio courts say to abate nuisances. They've always stated that. So it seems that the outward boundary of the state police power, of their regulatory authority, is the ability to abate nuisances. So you've got to look at what is a public nuisance, and is the smoking ban, in fact, a public nuisance? Well, a nuisance is defined as the wrongful invasion of a legal right or a legal interest. And the wrongful invasion encompasses the use and enjoyment of property or a personal right or privilege. So the first question you've got to ask yourself when you're talking about the state smoking ban, and particularly as applied to bars, I should take a step back, and I know that you don't study as applied constitutional challenges versus facial challenges very much. The Ohio statute that creates the smoking ban provides that certain types of property are considered public property or places of employment. And then public property or places of employment are then subject to the smoking ban. So it essentially is a regulation of property. It doesn't ban smoking. It doesn't ban smoking across the board. It creates a myriad of exceptions. But one of the groups not exempted is bars, where smoking has been traditional, and the economic effect on kind of the small corner mom and pop bars has been very dramatic, because these bars, as opposed to maybe some of the bars that you may frequent, tend to do most of their business after work. You know, a factory shuts down and all the union workers go have a few cigarettes and a few beers and whatever else, you know, kind of between the 4 to 8 p.m. hours. And this is the kind of bar that we represent, a bar called Zeno's. It's in Victorian Village, just a few miles from here. So our argument is that the smoking ban is unconstitutional in its application to bars, not overall, because bars are essentially a place where people have traditionally gone to drink and smoke, and much of their revenue is derived from there, and you're not forced to go there. Of course, bars are very different than government buildings, for example. We readily concede that it's a value use of the state police power to ban smoking here in the law school, because all of Ohioans' taxes flow to the law school, so it's fair that they have the ability to control the premises in some way through majority decision making. Similarly, you know, City Hall or Nationwide Arena, again, Nationwide Arena exists because of our tax dollars, so it's fair that the public has some input on whether people are allowed to smoke there. Bars, on the other hand, are purely private, and you have no right to be there. You go there at your own will if you choose. And when you choose to frequent a bar, you essentially are coming to the nuisance. So, do they still teach the coming to the nuisance doctrine?
We skipped nuisance in my class. Because he's close and nobody knew what it was. Lawyers didn't understand it.
Well, what are you going to do? I gave you the definition of nuisance. I'd be glad to send it to your professor as well if he needs to have a look at that. What's that?
He retired.
That's probably for the best. So the idea in the first instance, we've kind of described what a nuisance is. It's an externality that harms somebody who's not privy to the use of the property. And the idea has always been you have a defense if somebody came to the nuisance that you're creating. So we don't think the smoking ban is a nuisance because it doesn't interfere with the rights of others through externalities. But even if you conceded that the smoking ban the smoking indoors were a nuisance, you would still have the coming to the nuisance defense. The coming to the nuisance doctrine is the idea that if I, again, have that same smoke billowing factory and you build a residential home right next to it, you can't then sue me to enjoin the pollution that blazes all over your property, so long as it was there before. The idea is that you came to the nuisance, that you only have the problem of pollution on your property because you created it by nestling up right next to the problem. And this is very much true in the case of smoking within bars. You know, again, you have no right to go there, and once you enter, you essentially come to the nuisance, and you rescind your right to complain about the owner's allocation of his indoor air, which is a property right that we have. We have the right to allocate our indoor air. We have the right to allocate the air above the property, so that people have been found to be free from airplane noise that's above their property. They're found to own all the way up, you know, to space. space when you own a parcel of land. And so the same